Lancaster Neighborhood Vitalization Commission special meeting of August 21st, 2012 to order. I have 6 o'clock. We can go ahead and start with a roll call, please.
Thank you. Commissioner Concepcion Harris.
Present.
Commissioner Howard Harris.
Present.
Commissioner Hearns.
Present.
Commissioner Kiefer.
Present.
Commissioner Lawson.
Here.
Vice Chair Moulton.
Here.
Chairman Derryberry.
I'm here as well.
We have a quorum.
Thank you. At this point, I'd like everyone in the audience, staff, and commissioners to stand for the Pledge of Allegiance. Please place your hand over your heart and repeat after me. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Well, unlike previous meetings, I'm going to have this phone on my desk. My wife's about 2 weeks away from our due date to deliver our daughter. So if I get a call and run out of here, that's the reason why. So don't be offended by any means. Okay, this is a great turnout. I think we've obviously hit a trigger button because we've never had this many people show up to our commission meeting before. So we're going to start off with public business from the floor. This is a time for the citizens who would like to address the Lancaster Neighborhood Vitalization Commission on an agendized item. To speak on this item, please complete a speaker card. Individual speaker cards are limited to 3 minutes each. Do we have any speaker cards?
Yes, we have 9 speaker cards at this time.
And I suspect all cards are on new business item number 2, I'd imagine.
That is correct.
If it's okay with the city attorney, I'd like to go ahead and do new business item number 1, just to take that off the agenda. I need the approval of the commission to cancel the September 4th, 2012 meeting of this commission.
I'll make a motion to cancel the September 4th meeting.
I second the motion.
Any discussion? We'll take a vote. As suspected, the motion carries. We'll cancel the September 4th meeting. Okay, let's go ahead and get started with the speaker cards for new business item number 2. This is a time to receive public testimony, discuss and determine possible recommendations to the City Council regarding liability of property owners for vicious and potentially dangerous dogs in rental housing units.
Okay, our first speaker is Sally Grimm.
I'm Sally Grimm. I live in Antelope Acres. We have a rental house in Lancaster. I was a letter carrier for 29 years, and I know about dogs. The most vicious ones are the Chihuahuas. Oh, my gosh. And the renter was a really nice guy, and he asked if he could have a dog. And I said, sure. So he got himself a terrier or a pit bull. We raise pit bulls. They're not an issue. It's, the creeps that raise them wrong. And I had this all written out. I forgot it at home. We don't understand why we have to be responsible for something that he does. It's like making the car dealership responsible for the guy driving the car without insurance, or the Section 8 people doing what they want to do, and the government's not responsible. The neighborhood suffers. I don't see how I can be held responsible for his actions. He owns a dog. He licensed the dog. He's responsible for the dog. That's it.
Thank you.
The next speaker is Pat Cummins.
Yes, good evening. I have been a resident of the Antelope Valley for more than 40 years. My husband and I own 2 rental properties. which we have owned for a considerable length of time. My concern is that you would be asking the landlords to take responsibility for something that we really do not have control over. We put into our rental agreements no pets. Somehow we find out there are pets in the house. How can we be held responsible for something that we don't know exists? For one example, we had one house where they signed up, they had no pets. They had 2 pit bulls in the backyard. Only got rid of them after we filed an eviction notice with them. Then they got rid of the visiting dogs, because that's what we were told. The dogs were visiting for 6 weeks. And in order to stay in the residence, they did eliminate the dogs. We have the other one, no pets. Our gardener tells us there's a dog in the yard. So now they're paying a security deposit for the dog. We're not allowed to go in and inspect the homes without their permission, without making an appointment. So how could we know? Are we supposed to sneak around? Maybe your eye in the sky could look and see where the dogs are for us. I don't know. But I'm getting a feeling that this is more of a nanny state, that you want someone else to be responsible for the careless ways of other people that we have no control over. We do income checks on them, we do background checks, we make sure they've had no evictions, we've done other things, and yet still there can be problems. And honestly, in only the 20-some years we've been landlords, we've only had 2 evictions, which I think is really a pretty good rate. Some of them have volunteered to leave, and the dogs do damage, not only to our property, but to other people. But to ask me to be responsible for someone else's property, I think is just a little too much for asking me to take care of everything else. I pay my 25% income tax to the federal government. We pay about 8% to the California state, and I don't want to support anyone else. Thank you.
Thank you.
Dr. Bill Pierce.
I'm a retired aerospace scientist. I've been a landlord in the Antelope Valley for about 17 years now. I have 11 rental houses at the present. And most of the dogs that we've ever had to deal with were illegal dogs. We have no pets at move-in, and then the pets show up. The only way to get rid of a pet is to do an eviction. That's practically impossible with the landlord-tenant laws in California. The last eviction I did, there's a tenants' rights group in town that was going to require me to hire an attorney, go through a jury trial for a simple eviction, and it was going to cost several $1,000s. That's just impractical to make me responsible for someone else's pet, a pet that I have no control over. And as the previous lady said, I have no right to go in and inspect. You have to make a big deal about it. You have to make appointments, and they don't always let you in. I've even had police out that told me if I didn't leave the property, they would throw me in jail, the landlord, after I gave the 24-hour notice and everything. So it just makes no sense to make the landlord responsible for someone else's animal. Thank you.
Thank you.
Ed Dunn.
My name is Ed Dunn. I live in Canyon Country and formerly lived in this valley, and unknowingly married into a local pioneer family. We have a rental house in this town, is the reason I'm here, and it really shocked me, and I only read it because I picked up the Antelope Valley newspaper, And as a property owner, I would think something like this would be notified if this was going to have an impact on the homeowner. I'm shocked that since there's a state law that requires dog owners, or not dog owners, pet owners, to be responsible for the animals, that a city would try to put together an ordinance or a law or something that would be enforceable. And it's kind of subservient, I would believe, to the state law. It certainly can't supersede the state law. So we already have the state law that requires the owner of the animal, and that's the way it should be. We've had the same problem. Our lease agreement has the leasing person sign no pets. And we've had the visiting pets and eventually had to get rid of the pets, and the pets were chewing wires off of the controllers for the irrigation and chewing the wooden gate and doing damage. And fortunately, we didn't have a claim against injuries of children. And the pit bulls are pretty popular, and most of them come from training, and they've been trained to kill. And small kids aren't even safe around them. So I don't think that we as property owners should be in a position where the city holds us responsible, so the homeowner says, hey, you're responsible, so now I have to sue the homeowner. And then he probably turn around and counter sue me, and then I have to sue the city. And so we got all these suits going to this courthouse over here. And I've had an opportunity to visit that courthouse with some friends that were trying to settle a case. And you don't want more cases in that courthouse. They cannot handle the ones they have right now. And that's where I would see some of this would head, and would cost everybody a lot of money. And I don't see any way that the absentee landlord is going to be able to be held responsible. I don't think that's going to handle, that's going to fly anywhere in this country. And this may be the only place that's trying to do this. But I just hope that you decide against it, because it doesn't seem like there is a real practical way to enforce this and make it stick to the landlord. And I certainly hope not. Thank you.
Thank you. Now, since we have the liberty of having the city attorney here, I'm gonna not practice law for a second and ask him to assist us. We've had now 4 speakers that have brought to I guess some assumptions that they think that the way the law is, and I understand it to be something different. Now in regards to the landlord's liability under state law, I know that there are some requirements of the landlord currently. Can you summarize without this ordinance, Mr. McKeown, what is the landlord responsible of?
Okay, well, first of all, I think the last gentleman is correct that there is a state law that imposes liability upon the owner of the pet for any injury caused by that pet. That law does not apply to landlords. There is a series of court cases, basically a common law liability theory that imposes liability on the landlord, but only if the landlord has notice that the dog is and I use this term somewhat loosely, a vicious dog, meaning one that has bitten somebody or attacked somebody previously. So once they have noticed that they have a tenant with a dog that has attacked somebody, then they can be held liable for allowing that pet to remain on the premises. But up to that point, without notice, then they're not liable. That's the way the law currently applies in California. This ordinance would make that leap to require that the landlord be responsible for any attack by a dog that they allow or that their tenants possess on the property.
Vicious or not vicious? Correct?
Vicious or not vicious? No, whether it has a history of attacks or not, they would be. If it basically the first bite, they'd be liable for that as well as the owner of the dog.
In the way I understand it, whether they knew if the dog was there or not. Correct?
Correct.
Okay. Commissioners, anyone have any more questions for the city attorney before we move on to the rest of the
I have a
speakers?
question. When you say they have to give notice, what kind of notice? Is it written? Is it something that's documented in writing?
No. Notice under this circumstance is just knowledge.
Right.
If you, as the person who's been attacked, can prove that the landlord knew or should have known that this dog was a vicious dog, that something had happened before, then you can go after the landlord. But only if you can show that he actually had some prior notice or knowledge of the prior attacks by the dog.
Okay, so you have to have a prior attack.
Correct.
Okay, you can't just say you have a vicious dog that has
No.
an attack.
No, the statutory definition of vicious dog is one that has attacked a person or persons in the past, right?
Any other questions before we move on to more?
I have a question. My understanding is there have been cases where there was an intruder on a property and they were bitten by a dog and they were still able to sue. Now, would this pass on to the landlord in the event that you have a landlord, you have a docile dog like a Labrador Retriever in the backyard, someone hops the fence to intrude upon the property and is attacked by the dog, does that, the way this is written, that's following to the landlord as well?
That's correct. As it's currently written, correct.
Okay. We'll move on to the next speaker, if that's okay.
Sharon Green.
Hello, and thank you for your attention, allowing me to speak. I guess my concern is, one, I'm not really clear on what is driving this move to shift the responsibility to the landlord. As a landlord, I can echo the sentiments I've heard thus far in that I too had a renter who, on the contract, it was stipulated no pets. Model renter, dream renter, you'd love to have her. About a year down the line, she invited a girlfriend to live, the girlfriend's daughter, and the girlfriend's dog. Now, at that point, I could have chosen to ask her to, you've broken the contract, please have your friend and dog and daughter move, or you will get evicted. Luckily for me and for them, there was no incident, but had the dog been of a vicious breed, or even, as he points out, a non-vicious breed, but it attacked someone, I would be liable. And I think that the proposal as it is written right now has not been adequately bounded and nor thought out with respect to the existing current laws. And I would...
With that said, do you have any recommendations? I mean, we are here to discuss the issue. I mean, do you have anything, based on your experience, that would be of assistance to us?
I would simply say that I think the committee needs to sit down with this gentleman here and step out the stipulations under which a landlord could be held liable, and under the conditions that the landlord would not be held liable. It just has not been bounded yet, and that's what concerns me. Thank you for your attention.
Thank you.
Carol Kelly.
Good evening, thank you. I'm not a landlord, but I'm fortunate that my husband has a job and we're able to own our own home. If things were different and I had to find apartment housing, I might not be rented to because of my dog. My dog is 3/4 American Pit Bull Terrier. He is a well-mannered example of the breed and a registered therapy dog. A tenant should not be punished for having a well-behaved dog. It has been printed in the AV Press that our mayor suggested this step at the July City Council meeting, calling it just another tool we'll use to get rid of the pit bulls in town. There is no scientific proof that genetics cause a breed of dog to be aggressive, vicious, or dangerous. Irresponsible owners are to blame for the behavior of dogs that are aggressive, vicious, or dangerous. We have good laws in place. Enforce them. People need to be held accountable for their actions and the actions of those in their care. Forcing this responsibility on a landlord is a disaster. This cannot come as a surprise. Landlords will simply not rent to people with dogs, not just pit bull terriers. When dogs are banned or restricted, the responsible owner suffers the consequences, and the irresponsible owners simply continue operating outside the law. Tenants may begin hiding their dogs to have them. I do not appreciate letting gang members determine how I live. It remains, people need to be held accountable for their actions and the actions of those in their care. Punishing irresponsible dog owners who allow their dogs to behave inappropriately, regardless of the breed, simply makes sense. We have good laws, enforce them. Thank you.
Thank you.
Raymond Bauer.
Ladies and gentlemen, it's good to see some familiar faces on this committee that I've never heard of. But I've been out of town for a while, so.
Good to see you too, Ray.
Yeah, thanks. Pretty much everything has been covered and said. I had on here that any breed of dog can be vicious. Just, incumbent upon how the owner treats their dog and how the dog is raised. So, any dog could be vicious. And so my question is, since pretty much everything was covered that I had, what about a property manager? The property manager, you hire a property manager and the property manager takes care of everything. I may not even know who's in the house. I don't know whether they have a dog. I'm just sitting back collecting rent.
It's actually a really good issue. Fortunately, we have a property manager that sits on this commission that we can maybe enter into some dialogue there. I think you brought up the point where you have maybe an absentee landlord who lives out of town, out of the area, and maybe they're trying to do the responsible thing, right? They want to make sure somebody is watching their property. I think one of the major concerns about bringing this ordinance forward is this idea that you have an out-of-town investor that doesn't really care about Lancaster. They'll rent to anybody. So they don't care vicious dog, non-vicious dog. It doesn't matter to them. They don't care whether there is an animal. But if you have a responsible landlord that does care and they hire a property manager to manage their property, then what happens? And I guess that's maybe a two-part question. We can ask Mr. McEwen if that has anything to do with this ordinance, and then maybe ask Mr. Harris to respond.
Does the property manager become the landlord, and does he become liable instead of the landlord?
First of all, I share your sentiments.
Sorry, Howard.
No, that's quite all right, being that I am your property manager.
Well, thank you.
I think if the ordinance was to go through, it would probably go on and continue and include the property manager. Obviously, we have a lot of concerns here. There's a lot of things that have to be done to the ordinance to make it satisfactory to all the concerned. Typically, what I do as a property manager, I will allow you to have a dog as long as my owner's insurance will cover that dog in the case of something happening. If there are certain breeds that are not covered by your standard insurances, your more vicious breeds, and I will tell a prospective tenant, I understand their plight, but at the same time, I as a homeowner and I as a dog owner had a Rottweiler that was a good family dog. I had to switch insurance and go with Farmers because they were the only one that would cover the dog. So, there's a lot of things that could be put in place, but that being said, it's a situation to where, like a lady just said a little while ago, it's about holding people accountable. And I think there's something that can be done to make this work for everyone. What, I don't know, but obviously the ordinance would have to have some additional wording.
See, and Mr. Harris brings up a point that I think is paramount to this issue. It's that somebody has to be held responsible for what these dogs are doing. Because bottom line is a normal renter will not go into a property, take out a renter's policy that will cover something their dog does. So the bottom line is that these dogs in general, vicious, non-vicious, whether they've done this in the past or not, if they attack a young child, the young child needs recourse. So they want to make sure that somebody's held accountable.
Right. And I have that here about changing the renter laws, maybe, where it requires insurance.
Well, that's the same concept
I don't want to get moans and groans about it, but if we had it to where if there was, the rent included the insurance or something, maybe lobbied the state of California instead of making it a a city law, you know. I don't know. I just don't like this vicious dog thing because, you know, my little dog is a Jack Russell, and I do believe, like the lady said, if somebody jumped in my backyard, Gracie probably would bite them. But if you came up to the front door, she'd kiss you, you know. So, I mean, a dog has a right to protect its property just like a like an owner does of his own home. So, and there's no way this dog is vicious, but, you know, to protect the wife, she would bite. I know she would. So, that's all I have.
Thanks, Ray.
Thank you.
Michael Reeves.
Mr. Chairman, Commissioners, staff, ladies and gentlemen, what is a dangerous dog? When I lived down below, I had at one time 2 dogs that were Shepherd Dobie mixes, and they were gentle dogs. And I also had a little Cocker Spaniel. And I remember a couple of German Shepherds that were loose in the neighborhood that came in the yard, and the Cocker Spaniel went after him like crazy, and they took off. Is the Cocker Spaniel a dangerous dog? I think that we're setting ourselves up with this ordinance. State law makes the individual liable. I'm liable for my cats if they get out of my yard and scratch a kid and hurt him. I don't need another ordinance saying that if I rent out a room in my place and somebody brings a dog, that I'm going to be liable. That person's going to be liable. Is this a way that we're shifting liability to the citizens? Is this a way that we're trying to keep people who are Section 8 tenants from having animals? Or is this the way we're trying to go after gangbangers? I don't know. I think that we have to be extremely important tonight. Everything we say needs to be on the record, because I can assure you that there will be a court case, and the judge will come back and he will look at the minutes of this meeting and the city council meeting subsequent and base his decision. And probably he's going to toss this out because we're conflicting with state law. And one other point, I think this is a discrimination against senior citizens, because if I rent, like I said, a room in my house and somebody brings an animal in, then I'm liable. And in these economic times, I might have to rent a room in my place to live.
Are you calling yourself a senior citizen, Mr. Reeves?
I'm a senior citizen.
Okay, just wanted to make sure.
I'm a proud senior citizen. I'll be 64 in 2 months. Or if I want to move into an apartment, maybe I don't want to live in my house anymore. I can't manage it because I'm old. And I want to take my cats. Now we have this ordinance, and maybe the landlord will say, hey, you know, we got this ordinance against vicious dogs. Maybe I don't want to take a chance with Mike and his 2 cats, you know. So before we pass this, you know, I remind us that everything we say is going to be in court someday. And do we want, number 2, to try to supersede state law? And thank you very much for your time.
Thank you. I think the audience needs to be clear on one thing that I don't think is coming through. This statute makes no difference between dangerous or not dangerous dogs. The ordinance that's been put in front of us is any dog. The way that I understand the state law, and Mr. McEwen, correct me if I'm wrong, is it's a notice issue. If the landlord had notice that there is a vicious dog on the property, the common law has stated that that landlord is responsible. So I understand that by statute, the owner of the dog is responsible. Everyone who said that tonight is correct. But the assumption that there is no law that would require a landlord to be responsible is not necessarily correct. If the landlord knew that the dog was there and the dog had vicious nature, that landlord can be held responsible. I mean, there's long-standing law that justifies that. This ordinance, that's been placed in front of this commission for analysis tonight, takes it essentially one step further, and it asks the landlord to be held responsible whether they knew or didn't. I mean, so long as that the rest of the speakers are clear, that's what's being proposed. So if I misspoke at all, Mr. McCune, please correct me.
No, that's exactly right. And there have been a couple of speakers that have made statements to the effect that this proposed ordinance conflicts with state law. It does not conflict with state law. It extends that liability beyond what state law requires. It goes beyond the restrictions of state law. It does not conflict with them.
Which is allowed.
Which is allowed, and is particularly allowed of a charter city.
Correct.
Which Lancaster is.
Now, I guess there's a reason, and there's a reason that this statute doesn't, or excuse me, that this ordinance, the proposed city ordinance, doesn't specifically name vicious dogs. Am I correct with that as well?
It's also correct. There is a state law that would allow us to regulate on a breed-specific basis with respect to spade and neutering programs.
Which we've done, right?
Which we have done. We've already adopted that ordinance. But it prohibits cities from adopting any local regulation based on breed-specific determinations. And so if we were, and I must say that when Mayor Paris suggested this ordinance in the first place, he was very, very focused on pit bulls.
Right.
And Rottweilers, I believe, was his comment. And it was, only after that we had to explain, you can't do that under the state law. And so it's expanded to beyond just those two to make landlords basically strictly liable for the damage caused by a pet of their tenant.
Ms. McEwen, has there been discussion as to the specific order of things once a landlord becomes aware? In other words, if a landlord becomes aware that you have a dog that you may not have had when you originally signed the lease, if the landlord sends you a letter, is that enough to get him off the hook? I mean, it seems to me there needs to be specific steps that the landlord could follow, that in the event the dog stayed on the premises, the landlord is not responsible. I've done my duty. I've notified the tenant the dog has to be moved within X amount of time, and there needs to be some kind of enforcement that I could do to make the dog leave the premises, whether I have to call animal control to come out and remove the dog. But I think something needs to be there to buffer the landlord if he's doing his job.
Let me do this. Let's get through because the commission does need to have a discussion about this, if it's okay, Ms. Commissioner Harris, if we can defer that question to after we finish public comment so that the seven of us can discuss this issue, and then we can also refer to Mr. McCune if that's okay. So let's get through the public testimony so we can hear what the audience has to say, and then we'll start addressing kind of issue by issue basis, if that's okay. So go ahead and continue with the speakers.
Betty Gunther.
Good evening. I'm Betty Gunther. I live in Quartz Hill. My husband and I do have a rental house in Lancaster. And this would concern me whether or not we did, but what really concerns me is the issue that a landlord can be responsible for something they do not know anything about. In our rental agreements, like others have mentioned, we also have a statement that no pets. We have made exceptions after checking with our insurance agent, after going online and checking breed-specific, although I know that issues are not necessarily breed-specific. But we've done what we thought was all we could do under the circumstances without being kind of mean to a person, that they can't have their little pup or whatever. So anyway, I did check with my insurance agent again today, and he said that I have always been in a position as a landlord where I could be sued if a tenant's dog did damage to someone. So it would seem to me that this ordinance would just make it so that we remind the people that have been damaged to not forget to sue the landlord. I don't know.
The lawyers already know.
I know. So I guess I just don't get the point of the ordinance in making me, the landlord, responsible for something I have tried to avoid and keep from happening and don't even know about. I've had also tenants sneak the dog in after the fact, regardless of what the lease says.
And can I ask you, what did you do when you found out that the dog was snuck in?
Well, in this particular case, I didn't do anything because it was just a little pup and they were leaving soon anyway. So it ruined my new carpet because they potty trained it there, but, it didn't bite anybody, fortunately.
Now, hypothetically, what would you have done if you found out that it was one of the vicious breeds, Rottweiler? It was a Rottweiler. What would you have done at that point?
I would have gone to my attorney and asked him what my rights are, and then proceeded accordingly.
Because you would have been concerned, I'm just assuming, right?
Definitely.
But you weren't as concerned with the little pup.
Right. Because it was still just a pup, and they were leaving soon anyhow, before it would grow big enough to bite somebody, I hope. I don't know. Anyway, that's all.
Valid points. Thank you very much.
Nancy Pastoral.
I think that this proposal is ridiculous, and it is already covered by laws that are already in effect, and it goes against other things. It just goes against what is right. People shouldn't be held responsible for something they don't know anything about, for one thing. Something else, I think that animal control needs to take a little bit more responsibility. People are supposed to have pet licenses, so are they enforcing that? It goes back to the enforcement, again, of the laws. If they're putting an animal out for adoption, why aren't they spaying and neutering it before it leaves the shelter? Instead, they're telling the people to bring it back to the shelter later to get it spayed or neutered, and the majority of the people do not, and that's any breed. Something else is they do not check to see if you own your property when they let you adopt a dog. You can go in there and adopt a dog and take it home to one of these people's houses, one of these landlords' houses. They didn't have a dog when they moved in there, but now Lancaster Shelter has let them adopt a dog without checking with the landlord to see if it's okay, without finding out whether or not they have any type of liability insurance to cover it if it does bite somebody. Animal control needs to take a little more responsibility. Animal control needs to show up when somebody calls and says, there's a vicious dog next door. Instead of waiting for that dog to do something, they need to come out and talk to those people. I think that if I personally would never take an animal to animal control. I'll rehome it, I'll advertise, and I'll work for months to try and find that dog's owner. And if I can't find the dog's owner, then I'll find it a new home. So I don't have a whole lot of faith in animal control. But at the same time, since they are getting paid, maybe they should be doing their jobs.
Thank you.
Maureen Feller.
Hi. I've heard that a lot has been covered already tonight, but something hasn't been covered. Basically, you're saying that only homeowners can have the right to have a pet. I believe that over 60% of our residents in Lancaster are renters. Let's say half of them own dogs. When you pass this, what choice will a landlord have but to say, get rid of the dog? We're talking thousands of dogs. As the lady just said, she doesn't trust our shelter. I don't either. It's one of the highest killing shelters in the state. You are going to give a death sentence to thousands of dogs. I also disagree with the gentleman who says that pit bulls are trained to be killers, the majority. If that was the truth, we would have a lot of dead bodies on our street because we have thousands of pit bulls in this valley. We have a country that was made on individual rights and individual responsibilities. This is a lawyer's dream. Why go after a tenant who has no money? You can go after the landlord who at least is a property owner. And it's been brought forward by a lawyer who has stated for the last 4 years that he hates pit bulls and Rottweilers, both of which are part of what's called the gladiator breed. They can be fought, but they can also lay down their lives for their owners should there be any danger. Our mayor gets to own a gladiator breed. I believe the name of his dog is Jocko, a German Shepherd. He can take his gladiator breed, which has been trained to defend him, anywhere he wants. So what are we doing here? And where's the proof that the law that is not already on the book is not being held up? Is there a reason? Is there a reason why this is being presented? Have we had a rash of landlords knowingly let dogs attack people?
No, I think to address that, I think the issue is that we have a lot of landlords that just don't care. So the bottom line is all they care about is the dollars that come into their bank account. So as
Hold
opposed to
the renter responsible. If the landlord doesn't care, you already hit him with code enforcement, and you already have a law on the books. If the landlord knowingly allows a vicious dog on the property, they can be held responsible. It is already there. Rex, as he said in the paper, this is another tool to go after pit bulls. And if you guys pass this in your sterilized little seats, I think you need to go to the shelter and be there when they start putting those dogs that come in down. You will be responsible for them. I can't believe that this is even being discussed. Thank you.
Thank you.
Bruce Hailstone.
The voice of real estate.
Hello, Commission. My name's Bruce B. Hailstone, local real estate broker and property manager. Been managing properties for 20-plus years. Most of what you've heard this evening is pretty accurate. We, the people, don't believe this should be even an issue that a city should be considering. No more than making the renters' children the landlord's responsibility for their behavior. A dog, in most cases, is a member of the family. And I, for one, am not particularly fond of the, quote, vicious dogs. And as a landlord, we do not allow them in our properties. But it is a common factor that tenants, without getting landlord's permission, obtain these kind of animals. How can I be responsible for something I'm not aware of?
Now,
I do have a solution.
Glad to hear.
And I've talked to the city about this before. If the city were to require their sheriffs that every time a sheriff visits a household in a neighborhood, that the landlord be sent a 3x5 postcard stating, "We visited your property at this address today." Nothing more, nothing less, no accusations, but making a landlord aware that a property he owns has had a visit by the sheriff that was substantial enough that the sheriff would show up at that front door. That's what you call proactive law instead of reactive. I am ashamed in the fact that I owned a home a block and a half away from AV High School. I had a grandma and grandpa living in that house raising 2 baby grandchildren. They were there for almost 3 years. I knew he was an alcoholic. I know she had her personal problems. But by the time I finally had to evict these people for non-payment, by the time I got them out of that home, I had neighbors coming out of the woodwork to express their gratitude for me that I finally evicted these people that routinely had sheriffs showing up at their property, because come to find out, they were one of the biggest drug dealers in the entire neighborhood. And yet I, as a landlord that collected rent and saw this elderly couple every single month, did not have a clue that the sheriff had ever been to my property. I think that is a crying shame. We should be notifying our landlords when we have a problem at their property so they can be proactive and take the appropriate action before you have to cure the problem. The problem is not the landlords. The problem is some of the decisions that our city is making and not being more proactive in solving the actual problem and making the individuals who are responsible. Thank
Wait,
you.
Mr. Hellstone, Mr. Hellstone. Mr. Hellstone, I'm not done with you yet.
Time was up.
Yeah, no, I appreciate you monitor the time, but now it's on my time. So, first of all, I think it's a great suggestion because if the sheriff is called to a house for an attack by a dog, the landlord is then put on notice, what then meets state law, which then they would be held responsible. I think it's a great idea. Thank you. I think it's a great idea. Now, let me ask you a question. We all know that have been in this area how much experience you have in this industry. What do you do when you rent to a property to a tenant, or what have you done, where the tenant said there are no pets? Then you get notice that there is a dog, or let's just say, for the sake of argument, there is a pit bull. What would you do?
We allow pets, just like we allow children. The bottom line is we do have what we call our pet application, which includes the 10 worst dogs. And unfortunately, there are some breeds that are known to be a little bit more aggressive than others. If, in fact, an individual has one of those pets, we either deny them or we double-check with the landlord, the actual property owner, and typically will require minimum insurance that will cover that dog specific, if, in fact, the landlord does agree. But 9 out of 10 times we simply disallow occupancy. Although, once occupancy is taken, an occasion, a tenant will take on a family member's dog or some such thing, and if it is one of those 10 worst animals, unfortunately, I've had that situation.
So what'd you do?
I write them a letter correspondence stating you obviously are in violation of your original lease. Either the vet has to be removed or we'll begin the eviction process. It's a choice.
Have you actually evicted somebody for not removing
I haven't
the pet?
had to. They've always done something with the animals. And more times than not, it's somebody that had the animals to start with that said they would keep them at mom's house or something, and they end up bringing them to the property in which they lease, unfortunately. And then we, as proactive landlords, take the appropriate action to eradicate the problem.
So you took responsibility for your problem?
Yes, and I don't think that's the city's responsibility. It is mine as the property manager.
Right. All this ordinance is trying to do is make the landlords take responsibility for their problem. You eradicated the problem. You got rid of the pet. That was the issue. When you got knowledge of it, you got rid of it, right?
If there was a complaint made by the sheriff's department about my tenant, and I got noticed from the sheriff's department that they visited my property for whatever reason, I, as a conscientious property manager, would contact that tenant to find out the why and take the appropriate follow-up action.
Which is what I think the city wants. So I appreciate, that you would show up tonight. None of your colleagues are here, besides Howard, of course. I appreciate it because, many of the individuals in the audience are landlords as well, but you manage dozens of properties, if not hundreds of properties, I'm not sure. So, you've been through a lot of these issues, so I appreciate you coming. Thank you.
One thing I do believe is that the city shouldn't be in place to micromanage. Let us do our job proper and then penalize those that are stepping out of line, not the rest of us trying to meet a stringent ordinance.
No, and I agree with you 100%, but we need to make those that aren't doing their jobs as landlords be responsible. That's what this ordinance is trying to do. So maybe we need to find a common ground. Well, I'm not saying this ordinance is perfect. In fact, I don't think it is. But I think that there needs to be a common ground so that we avoid the absentee landlords from renting their house to who cares. All they care about is the check that comes in the mail. You are a proactive property manager for your clients. That's what we want out of a landlord. That's all this ordinance is trying to say. We want people to take responsibility for their properties. They invest money in these properties. They should be held. They should take responsibility for them. When you find out there was a dog that met one of those 10 criteria, you sent them a letter and you eradicated the issue. We want landlords to take responsibility for their properties. All of these people here in the audience, they have done the exact same thing. We don't have anybody here that's an absentee landlord because they don't care. That's what we're worried about. This ordinance may not be perfect, but we're here to try to figure out what we can do to fix it.
Sir, I'd like to know what numbers are we really talking about? Are we changing ordinances and manifesting these kind of new rules that will affect the masses because we're dealing with one fraction of 1%?
Unfortunately, that fraction of 1% is what causes us to have laws altogether.
Sir, that should be handled far more efficiently by implementing a different kind of system that will actually hit the core of the problem and make the individual who's causing the problem the responsible party, not some third party who's tried to help give somebody housing.
And as I said, you brought up great points, and I appreciate it. So, thank you for your time.
Thank you.
Pam Lawrence.
Hi, I'm Pam Lawrence. I'm also a property owner. Own 25 units in Lancaster, 10 in Palmdale. Been doing this for about 20 years. First of all, the current law is sufficient. There's already the extension of the property, the pet owner is responsible for the pet, like I am responsible for my child. My job, their job, but now we already have the law that's existing on the books that says if that goes wrong, I am already responsible. So I'm concerned about the extension of the responsibility shift. Not only is the current law sufficient that says I'm already responsible if the dog goes bad, if I knew about it, and by the way, the first bite is everybody always says, oh, it's such a sweet dog. I don't care if it's a little dog or a big dog. I never knew he was going to bite anybody. So it doesn't matter what the breed is. I don't think we're talking breed specific here. The fact that the first bite is a surprise, where's the liability end? If we're looking at the same way, I don't want to take and not let tenants have pets if they choose to. But in the same way, if I've got a rental agreement, if they break the rental agreement, whether if they move extra people in, whether if they move extra pets in, whatever, the rental agreement's the rental agreement, that's where I use to evict or not evict. We have an agreement. If you broke it, you got to go. I don't care what the reasoning is. So if we're trying to take responsibility for running the business, which it is, running the business well, then I'm sorry, I'm flight of ideas here. The other thing is that I can't even not take pets. We now have, I'm getting aware of, that if somebody claims that their pet is a
Therapy dog.
A therapy dog. I have to have therapy pets in my one building. I have pets allowed, one building I do not. And right now, the building that I don't have pets in, I find out I have to have pets if they bring a letter that says it's a therapy dog. So right now, we're kind of going, and I hate to use it because it's a cliche and I don't like it, but we really are pulling this deep pockets thing. Whoever can pay for the situation instead of who's responsible. If they need to be responsible for their dog, they need to be responsible for their dog or get evicted, and penalizing me and extending this liability onto our shoulders when the existing law is already in place. Thank you so much.
Thank you.
David Paul.
Mr. Chairman and Commissioners, good evening. I wasn't going to speak, but I'm sitting there and I'm hearing a few areas that I would like clarified. First of all, and we can wait till I spit them all out, the ordinance itself, the enforcement of the ordinance, it is a fine. Is that correct? It is not a linking to any liability, because if we do that as a city, and I'm not a lawyer, but it seems that that would draw us into any liability. So are we talking about a fine, and how is that fine levied? Is there a board that determines that the landlord has taken all steps possible to assure their properties are safe and in compliance, but due to other circumstances cannot? So, it's like even when you get a parking ticket, there's somebody that reviews it, and it seems like these things are going to be very complex and lengthy and time-consuming. And I would just like to know, if we attach the city in some liability fight or if we're just fining the landlord. That's my points. Thank you.
Mr. McEwen, can you clarify that for us, please?
As currently drafted, this ordinance just imposes liability
Right.
upon the landlord, and it does not impose a fine.
That's what I thought. Thank you. To answer your question, Mr. Paul. Any more speakers, Linda?
One more, Jonathan Kennedy.
I'm a colleague of Bruce's and Howard's. I'm Jonathan Kennedy. I manage more than a couple hundred units in the Antelope Valley. Have been doing so for 26 years. And I agree with everything that Bruce says. And there's a even more important situation that comes into play here, and that is a landlord cannot enter a house that landlord owns or manages without it being for one of four reasons. Civil Code 1954 spells out those reasons. 1, in case of emergency. 2, to make necessary or agreed upon repairs, etc., etc. 3, when the tenant has abandoned or surrendered the premises. And 4, pursuant to a court order. So, can a tenant hide a dog from a landlord? Absolutely yes. You are putting the landlords between a rock and a hard place. They cannot find out if the tenant knows how to keep them from finding out. They cannot find out that the tenant has a dog. Yet, they are liable for that dog's actions. That's all.
Thank you. We got one last add-on.
Chris Persley.
Hello. I didn't want to come. I am a dog lover and also a landlord here in Lancaster. I appreciate that we're able to do business in Lancaster. I think any kind of ordinance of this sort is not business friendly. I think that there's no way that I can sit on all our properties and see every dog that comes in and out. Obviously, if I had a vicious dog, the tenant would receive notice. But our laws, as it is for landlords, is so limited, and we don't have a way of putting cameras in to see what they're doing. There is no Megan's Law for dogs. So when you have a dog, and honestly, I wanted to bring my dogs in. I have a 150-pound Mastiff, and my husband has a little 18-pound dog. And if I were to ask you by looking which you would view as the most vicious, obviously people would think the big dog, but you're more likely to get bit by the little dog. But I take responsibility for my own pets. I would not rent and expect a landlord to take responsibility. I think, as a matter of fact, it's ludicrous. I think the current law is sufficient, which you've heard that enough. We do impose a strict pet deposit. We charge a tenant $600 when they have a pet. That hopefully is a deterrent for an irresponsible pet owner to have a pet on our property. But I'm not able to police, nor am I able to gauge whether a dog will bite. And I don't think that I, as a landlord, should be responsible. As Mrs. Lawrence said, people are skirting around the law. I would prefer to have no dogs. But what happens when you do that is doctors give people notes, and there's more than just the service dogs. Now there's also comfort dogs that people are getting doctor's notes, and they can get it even from just a psychologist, a note saying that the dog is a comfort to them, and then we have to accommodate that. I don't think, that I think the current law is sufficient. I think you're putting an unnecessary burden on business people. I think that it's unfriendly, And I think that we are not able to police every single thing that happens. I have some properties that the people pay their rent and we don't have a problem in the neighborhood. I don't go often enough that I would even be able to handle something like this. And obviously, we do serve notice. We had a tenant just last month that had 3 dogs.
And what happened, out of
Gave them
curiosity?
a 30-day notice. We said, you have to leave. They left.
They left.
Yeah, we don't have irresponsible tenants. Also,
Yeah.
I just had a few. Yeah, I'm so sick as a landlord of being punished for the bad landlords in Lancaster. We're having to now have inspections of our properties. We're being taxed, which is a tax. We're being fined. It's not fair that we as responsible owners have to suffer for the irresponsibility of, and I don't know, as Mr. Hailstone said, who they are. I don't know any irresponsible landlords. That's it.
Thank you.
Thank you.
So now we're done with the public testimony. I'll start. The way I see this ordinance is it definitely has its flaws. I think Mr. Kennedy brought up he was really the first one to say it explicitly. You can't go in to police your house unless you meet one of those 4 criteria. Bottom line is, if you are a responsible landlord and you're trying to do your job, and the tenant hides the dog, you did your job, I think. I mean, you're trying to meet your burden as a landlord. You're being a responsible landlord. You can't control everything the tenant does. I agree with that. I heard that loud and clear tonight. I also heard something that I think is very important, and maybe this isn't so much a city ordinance issue as it may be a local policy to do exactly what Mr. Hailstone said, to put those landlords on notice that this is happening. Because then we may not even need an ordinance if we can try to meet some common ground with the sheriff's department to put the landlords on notice. Had Mr. Hailstone been notified of the drug dealing tenants, he would have evicted them a long time ago, as opposed to probably accepting the rent. So at the end of the day, once they've been given notice, we don't really need the ordinance, is the way that I understand the law. I mean, the landlords are responsible. If they knowingly lease the property to somebody who has a vicious dog, then they're held responsible. I hear that loud and clear. Bottom line is we want people to be responsible. Ms. Persley, I think, left. Did she? I was going to pick on her a little bit. I mean, we want everyone to be responsible, and maybe we can find a common ground with the sheriff's department to better police these. I don't know. Do we know what the statistics are about the number of reported dog bites that don't go to the landlords? Lee, do you have any idea?
Well, I would say this. I mean, as far as the notification, depend on what the situation is. Readily just calls for service aren't available to the public as a rule anyway.
Right.
Okay, because there's some information is confidential depending on what the nature of the call is. I would say this, just as we've done in the past when I was a narcotics detective, we notify the landlord if we were producing a case together, just part of our case involvement. If we had a continuing problem at a property, we brought the property owner into the fold. If they were taking some positive action to help remedy that problem, then we didn't make them accountable for the result of that, as long as they proactively worked with us. I would say in the situation here, we have some vicious dog calls. I could certainly pull those statistics and provide them to you, depending on, and give me a parameter of dates that the commission would like to see, and we can see really how enormous that problem is.
If we could pick 12 months and just figure out in 12 months how many calls did the sheriff's department receive from a dog attack, or because I've read plenty of stories, whether it's a 5-year-old girl or whether it's a dog attacking another dog. That typically happens as well. Does the sheriff? I mean, how often is the sheriff called out for that?
Well, that's also the other issue. Animal control, we could pull from both. I think to get a good perspective on it would be from both the sheriff's department and animal control.
And I think that's and obviously it's hard to know really you can't drive down a neighborhood and know that's a owner occupied, that's a tenant, that's an owner occupied. It's not readily available information. So that also provides a little bit more difficult situation to police or monitor for animal control or the police department. But I mean, we can't have the sheriff's department go into a house and the first question is, are you a tenant? And who's your landlord?
That was the point I was just going to make, especially in light of recent issues with the Department of Justice and everything. That's become an issue, asking actual persons who reside in a unit what their status is as far as their occupancy, whether they're renters, if they're a subsidy tenant, if they're a property owner. So, it would just, there's people volunteer that readily as well. But I would depend on, if we had a vicious dog complaint, it was an ongoing issue, I would believe there would be substantial calls beyond that from the neighborhood as well. And we've had those. I mean, I'm aware of several myself.
Well, I think if we could find out what happens after those calls are made, I mean, maybe we can request in some capacity to the Sheriff's Department, if there is a call, find out who the property owner is. If it is the property owner is the person that the complaint is about, then obviously it's probably an owner-occupied property. If the property owner of that property is not the person that the complaint is about, who is the dog owner, then we need to notify the property owner. I mean, I think that point is well taken. Because bottom line is I agree. Whether you don't want to be held responsible for something you didn't know about. I think that's my personal biggest issue I have with this ordinance. I do think that for the 5-year-old girl who gets her arm bit, and I want someone to be responsible for that. And I get it. The tenants don't hold insurance, and everyone out here is going to say that this is just a lawyer's ordinance. But bottom line is if you have a 5-year-old girl that's attacked by a dog, I don't care what kind of dog it is, somebody needs to be held accountable for that. And if the landlord knew that the dog that they had at the property is there, the law already provides that the landlord is responsible. I agree with all of that. I just want, I want to make sure that 5-year-old little girl is taken care of in some manner.
I agree with you. The thing I'm most concerned with is if you're going to hold somebody accountable for knowing there's a vicious dog on the premises, you have to give them a parameter by which to correct the situation. If I know I have a vicious dog living in one of my rentals, I need to have action that I could take to get rid of the dog, and I need to have the enforcement be behind me to help me get rid of the dog. The problem is it can take 4 months to evict a tenant for not paying rent. So you start getting into trying to get rid of a dog. It's not as easy as just giving them a letter and saying get rid of the dog. They can get rid of the dog for the day. They can bring the dog back. You got all kind of issues behind telling a tenant to get rid of a vicious dog. If they don't want to get rid of a vicious dog, they will skirt around the law and keep the dog.
Oh, absolutely. I mean, my office is no secret. I have an unlawful detainer department. I represent landlords in my practice. I know how long and incredibly frustrating it is to evict somebody, and I've dealt with the issue I think it was Dr. Pierce had with the group in town that demanded the jury trial. I mean, these issues, it is almost, I mean, California is so they're so tenant friendly anyways but that's a whole nother issue. But I mean, I get it. I don't know. I guess it's futile to say that we enlist a one-bite rule, because if it's a one-bite rule, we don't need the ordinance, I think, is the way I see it, Mr. McEwen. I mean, if we need the landlords to be on notice, then we don't need the ordinance, right? Because this California law already provides protection for the injured party, if I understand everything that we've talked about.
Well, the real question is are the landlords on notice? That's going to always be the question in a liability trial.
Of course.
So and there have been some suggestions on how we get notice to the landlords. And once we do get notice to the landlords, then the ordinance is no longer relevant.
Right. I think that's exactly.
Yeah. I think that's a valid point. The question is, how do we get notice to the landlords? We have the chronic nuisance ordinance, where if you have once you get to 4 calls for service at a property, then the property owner, without regard to whether they are the occupant or the the landlord or whatever, they get a notice that their property has been the subject of at least 4 calls for service. Once they get to 5, then they're subject to fines. And after that, unless they do something about it, they will continue to be fined for each service call.
Well,
So, I mean, we've got that ordinance already on the books.
Now, so obviously, if there's been four calls for a vicious dog or for whatever dog, then the
quite
fifth
frankly,
one,
I don't know, Lee. I'm not sure the chronic nuisance ordinance currently deals with vicious dogs.
But I would say to you, it's very simple to put a mechanism in place based specifically on this issue, okay, for a vicious dog, to be able to flag that statistically from the RAPS data, from the deputies' daily logs, and then put it upon us, and we could probably put something together in a protocol in the Public Safety Office to make that notification.
See, why don't we focus on... Sorry, Lee, go ahead.
Whoever has care and control for that property, okay, so it would take a minor amount of follow-up to establish that and make that notice. Then if we could track that notice very simply in a database here on who's been notified in case, but again, tenants change over too. So, there's some changeover as well. So, those are some things that we'd have to put together and to make it responsible too as well.
But one thing is the landlords rarely change over. So if you have a landlord that habitually rents to tenants who are irresponsible, then that landlord should be, maybe Mr. Paul's point about is this a fine or is this liability, maybe we should turn it into something similar to the nuisance ordinance and turn this into something that the landlord is maybe fined. I mean, because once they're put on notice one time by the sheriff's department or animal control, however we work that out, then they're on notice. We don't have to worry about the liability statute from the city of Lancaster standpoint because the California law already protects the injured party in that circumstance. But why don't we take it and work on something to take it one step further, that if the landlord is notified one time and then they get another call out, then they have to pay a fine to take care of the cost of the time for the sheriff to go out on a second time.
Well, that's really what it comes down to. Even for animal control, we contract for those services. So there is a resource drain for the community on these habitual problematic properties. I think, it would be for all of us to discuss from a staff level on how we'd implement that, and then for the discussion for the commission to come up what you would like to see based on your conversation with the public, and then collectively come together and put something together to address it. There's a mechanism we can put together to do that, and obviously if it's not working in the manner that we have it, we just change it. We can't be afraid to change it.
I mean, I think, and again, I feel like I'm talking all the time, so if somebody can step on my toes, go ahead.
I'm coming from a rather different perspective I shared with Patty. I am a victim of being bitten by a dog as a child.
Wow.
And it was my father that came to my rescue and with one foul swoop kicked the dog and broke its hip, and then it left me alone. But I can actually recall saying, "Sue him, Daddy, sue him."
They get fake TV for that.
But it was at the advice of the owner of the dog who encouraged me to pet the dog while it was eating. As a 5-year-old, I didn't know that the dog took that as a threat. The owner should have known that. I didn't know. So when we talk about placing blame on the landlord, where is the responsibility for that owner of the dog? Does it just bypass, or does it work in tandem with, so that if the landlord is responsible, so is the owner of the dog, or how does that work?
Well, the owner of the dog is always responsible, and we haven't touched on that today because really, quite frankly, that's not something that we need to talk about. That is deeply rooted law, and a couple of the members of the public have discussed that today. The owner of the dog is responsible, period. But when you get into the situation where, for instance, I'm a homeowner, you come to my house and my 3-pound Maltese bites you and breaks your skin, I have homeowners insurance that would probably cover that situation. But typically the tenants don't carry insurance to cover that particular situation. So if you have something that's much more vicious, I think the city is looking at trying to find a remedy to make sure that those situations just don't occur. That landlords just aren't negligently renting their properties out, that who cares that they're monitoring the properties? And if animal control or if the sheriff's department sends them a notice, puts them on notice, we don't need this ordinance, and maybe we come up with something else that's more fine-based, just so these landlords so they take responsibility, I think, is really what it comes down to. I don't think, and this is my opinion, I don't think that we can hold the landlords responsible the first time. I don't want to do that. But I think that the landlords, if they get habitual calls that's draining the resources, then they should also be held responsible along with the tenants.
I agree with that. The only thing, and I'm actually repeating myself, but I want to make sure that it's understood, in order to do that, you have to give the landlord stringent rules they can do to eliminate being held liable. If I know I have a vicious dog in one of my rentals and I notify them in writing, whether it's certified mail or whatever, and I have documentation that I'm in the process of trying to get this tenant out of the house and something happens in the meantime, I should not be liable.
No, I agree. You've met your burden at that point. I would think that if the landlord is trying to actively evict the tenant, and in the state of California, unlike Texas, which is you can literally get somebody out in 3 days in Texas. In California, it could take 4 months. And then if you deal with the jury trial, I've had clients that, that things have dragged out for 6 months, 7 months on an unlawful detainer, all while the tenant is living there for free. I think your point is well taken. I think that we should, if we put something in motion, that if the landlord receives a second notice or something, whatever we come to, after they've either enlisted some kind of the eviction process and they've worked on getting the tenant out, that at that point they wouldn't be responsible. But if they ignored the first notice and they let it happen again, then by all means they should be held responsible in some capacity. Maybe it's a fine. I don't know. I think it's something to consider. Go ahead, Michelle.
I just actually have a question and a comment or a suggestion. I don't know how silly it is. But my first question is, so some of the landlords here or property managers say that they do allow pets. So just like you said, if a small dog bites a child or something and it's, stitches or something, obviously it's not going to maul like a big dog would take over something. But if a property owner knows that there's a pet there and there's an issue, then where's the liability on that? That's just my question, because I'm not sure of the laws on that.
If the property owner knows that there's a dog there, I don't think it matters whether it's vicious or not. I think if they know that there's a dog there and the dog does, and Mr. McHugh is nodding at me, so I'm going to keep going. If the dog does bite somebody, for instance, if I have a property that I've rented and it's a Chihuahua, I don't remember who was the mail worker, I think ma'am you were, and the Chihuahua bites somebody, and I'm the landlord, and I knew that Chihuahua was there, and I know the tendencies of those crazy Chihuahuas, then I can be on the hook. Liability-wise, I can be on the hook as a landlord, regardless of whether this law is here. Okay, so it doesn't matter, vicious or not. If the landlord is on notice, whether it's a vicious dog or a non-vicious dog, you are going to be on the hook. Okay, so that's already there. We're trying to figure out ways to clean up the mess in regards to these rented properties.
My other thing is, I agree animal control should take more of an active role in this, but also what if, I don't know how ridiculous this is, but what if we put some kind of sticker or something so when the sheriffs do go to a home, and just for any kind of call, and they see that it's a renter home, just right off the beginning, that they can do notice?
I think, Mr. McHugh and I think we have many issues with that. I don't know, maybe I'm wrong.
I think there are a lot of issues with that. It's part of it. You've all read about our continuing discussions with HUD on various issues, and that is certainly one of their focused areas, that treating somebody simply because of their status as a renter, treating them differently than a homeowner is a problem for a variety of reasons. The one question I had is, and maybe it's back to Mr. Harris, is the scope of the insurance requirement. The landlord is maintaining the property owner insurance, and there are some dogs that aren't within the coverages of that insurance, and maybe it's the insurance requirement that we look at, that if the property owner is maintaining insurance that covers the dogs that he allows in, that we let him out.
So basically, if as a landlord I have the proper insurance, that covers non-vicious breeds, then the liability stops there.
Well, I mean, part of the problem with that, if we stop it right there, is that then the person who's been attacked doesn't have the right to make a claim on the insurance. You got to get to the point where you can actually make a claim on the insurance. I don't know. It's just something that's.
Well,
I'm trying to develop.
I guess the thing I'm saying is, if I knowingly have told the tenant, or if I've told the tenant that this breed is not allowed, and they have a dog that is not on my lease, that responsibility is on the tenant. If I'm made aware and I take proper action, we've discussed that, but it has to go back to the tenant having a fair amount of responsibility.
It does. It always does.
I completely agree with that.
I mean, if nothing else, before we do an ordinance like this, maybe we enforce that if you're a tenant, you have a dog, you have to have renter's insurance to cover the dog. I mean, it's a situation to where we're trying to make the landlord, who's trying to make a business work, providing housing, and we're penalizing him. If we're going to do that, then let the tenant who wants a dog have to have insurance to cover the dog. As simple as that. I mean, he's a member of the family. If you want it, you got to pay for it. I mean, I don't know. It's just about being responsible for your actions. You make your kids pick up the dog manure in the backyard if they want a puppy.
That doesn't work very well with my 5-year-old. I guess, I mean, I'll defer to staff here for a second. Now, the council wants us to make a recommendation, if I understand that correctly. And can the recommendation be as pointedly as we just don't agree that the ordinance works? Or do they want us to go through and, and give them a report about the different options we've come up with? Because I don't think, and commissioners, correct me if I'm wrong, I don't think that we've come up with one solution. I think we've come up with a few options that need to be considered by the council. Is that sufficient, or do we need to pointedly agree on one and then take it up?
Mr. Chair, what you just indicated would probably be sufficient for the council, because again, they're looking to get feedback from not only the public testimony tonight, but also want to hear back from this commission as to how they vetted out the issues and what they would come up with recommendations for the council to consider if it were as an amendment, or how this ordinance gets crafted, or if it's some other type of mechanism, as you guys are talking about now.
Yeah, I really think it's the function of this commission to, if you have a concern about something that's being proposed, express the concerns.
Right. Sure.
That's why you were appointed.
Sure.
And I think that's what the council's looking for. Now, they may not like the message that you send back to them, but they sent it to you and asked you.
And they appointed us, so hey.
They appointed you. So I will strongly defend your right to give them an expression of your concerns.
I mean, they can always remove us, right? I mean,
exactly. I mean, I really do share many of your concerns about this ordinance, but we had to prepare something to start the discussion.
No, and I think you clearly did. I think that what I heard tonight from the public that showed up is that while there may be people that think that this ordinance is fantastic, not one person took the time out of their Tuesday evening to show up to say that this is a great ordinance. So that, to me, is paramount to the issues that we're faced with. So with that said, I mean, my recommendation is, and this is obviously open for discussion because this is just saying me. This is my recommendation, is that I don't think that the ordinance as it's written is something that can be acceptable to this commission, based upon what I've heard from the public and the conversations today. However, I think based upon the discussion today that that there are ways to police the issues that the mayor and the council are concerned with, and I think it's twofold, maybe threefold, I don't know. I think that we need to work out a relationship with the sheriff's department because I imagine the Sheriff's Department's already doing it. Lee's advised us they keep reports on everything. Maybe we just need to take it one step further and find out the reports that are related to dogs. And then from that, we need to try to see if we can police, which ones are landlord-tenant issues and not owner-occupancy issues. And then somehow, maybe we work out an ordinance that after the landlord's notified once, and if they don't work to remedy the issue the second time, just like the nuisance ordinance, then they're fined. Because let's face it, liability-wise, there are plenty of things that happen, car accidents, dog bites, that no one's ever sued for, that there is no one that really takes liability. But if the city is truly concerned about these animals that could attack or that are vicious, then let's show the landlords, hey, the first time is free, the second time you got to pay us money because you're allowing these people to be there against, maybe that's an option, and maybe we have to work with. I think the city has to work with the animal control and the sheriff's department, because those are the two entities that will be put on notice. And I think when there is an issue with the dog. So and to piggyback on Howard's issue is that if the landlord is working to remedy the issue, I don't think the landlord should be held responsible for a fine or anything, because they're working to do what they can. But unfortunately, California law really handcuffs the landlords because the tenants have an immense amount of rights.
Chairman Derryberry, would you be willing to form a committee, a smaller committee from the commission, to work with staff, and we can have that conversation with the sheriff's department as well as animal control?
Absolutely.
Develop that.
We can form a committee without a notice on the agenda, right? So what I'd like 3 commissioners. I'll volunteer myself first.
Certainly.
Well, the 4 of you, have any objection? I guess we need somebody. I'd like to volunteer, and I hear that Mr. Harris and Ms. Moulton would like to volunteer as well on this. I'd like to form a committee to go ahead and tackle this issue with the city staff, maybe as well as the animal control and the sheriff's department, to see if we can try to work towards a common goal. You as well, Michelle? So it looks like the 4 of us would like to form the committee. We need a motion to approve the committee, correct?
How many members do we have total? You can't do more than 3
without
creating a Brown Act requirement.
Oh, that's right. So we can Rochambeau for it, I guess. You sure? Okay. Well, the 3 of us then, Mr. Harris, myself, and Ms. Moulton, would like to volunteer for the committee. We need a motion to approve the committee, correct? So I'll entertain a motion if somebody. I'd prefer not to do it myself.
Am I allowed to make a motion being part of the committee?
Sure.
Then I make a motion that the 3 of us form a committee with the city of Lancaster to investigate this further.
I'll second it.
Okay, all in favor, please vote. Any opposed, I guess? Okay, so our commission tonight has appointed a subcommittee to review this issue with city staff, the sheriff's department, and animal control. Commissioners have any other comments, or do you think that we've given enough of a report? I guess staff, do you think that we've given enough of a report?
Yes, sir. I think you've given enough, and you've given us some direction to work with you with the subcommittee and city staff.
I would just like to thank everyone that came out tonight. This is like at school. When you have the teacher conferences, the parents that are there are the ones that probably really don't need to be there, and you are the folks that are the responsible landlords, and we really appreciate you coming out. And like Chairman Derryberry said, the folks that are against this or that we have problems with, and there are some landlords that we have problems with, they aren't here. And I really appreciate all of you taking your time to come out and talk to us. Made some great points. We really appreciate it.
And your points were all well taken. I know a lot of times you get up here and the public thinks they're against us. We're here to take information to report it back to the city. We've been appointed by the council for a particular reason. So everybody's point was well taken. So again, I greatly appreciate it. I'll piggyback on what she said. So
thank you very much for being here.
So with that said, I think we've We've completed our agenda. I don't suspect any commissioners have any comments. Any comments tonight, commissioners? Anything else? Staff, any comments? I'd like to thank the city attorney for taking time out of his night to stay out in Lancaster. Anyways, we'll go ahead and adjourn. I have looks like 7:29 and no baby yet. I'm adjourned.